The gentleman from North Carolina is recognized.
Madam Speaker, we still haven't heard an explanation for why this legislation deems it appropriate to eliminate arbitration for parties of all sizes. We keep hearing about the little guy versus the massive corporation. And even in that circumstance, of course, what we may be talking about is like the case from 2011, AT&T Mobility versus Concepcion, where the issue was people in California had bought cell phones. They'd been told to offer a free cell phone, but wasn't made clear that they'd have to pay the sales tax. They thought they had so it was a $5 claim per purchaser, and somebody wanted to bring wealthy plaintiffs, class action lawyers wanted to bring a big lawsuit with tens of thousands of them. They might get a $5 coupon. The lawyers would buy a new jet. But that may be, in some circumstances, even the dispute with the big guy. But leave that aside. We still don't hear any explanation for why you're wiping out arbitration as a means that parties choose even if they're on equal bargaining power. And with that, Madam Speaker, I yield 2 minutes to the gentleman from Wisconsin, Mr. Tiffany.
The gentleman is recognized.
Thank you. Happy St. Patrick's Day, Madam Chair. And I just want to gently correct my colleague from North Carolina when he cited 8% inflation. On an annualized basis, we're seeing it being measured at 10% here. And I can understand the representative from Tennessee's sensitivity towards Biden inflation. Today we're here because the Democrats want to pass legislation that insults the intelligence of Americans. According to my colleagues on the other side of the aisle, the only people sophisticated enough to enter into arbitration agreements are unions. So they have exempted them from this bill. Convenient. This legislation prohibits pre-dispute arbitration agreements, which are fair, efficient, and effective way for consumers, workers, and businesses to settle disputes without costly and time-consuming litigation that mainly benefits the trial bar. This bill will also deprive Americans of an effective legal option while costing them more time and money. Pre-dispute arbitration agreements exist in many employment and consumer contracts today and are enforced like any other kind of contract. Arbitration is generally fair, often leads to better outcomes for workers, and does not keep claimants from simultaneously alerting the world to bad actors. Those agreements create a win-win situation for parties to contract in advance on a process for resolving future disputes. Courts accordingly uphold and enforce lawful agreements to arbitrate when disputes arise between parties, an approach consistent with the fundamental principle that arbitration is a matter of contract. This policy of individuals being free to contract has arguably long been a feature of American law. Existing law also permits courts to invalidate agreements under generally applicable contract defenses, such as fraud or duress. Some will argue that arbitration requires confidentiality. This is not true. The parties to the agreement always have a right to disclose details of the proceeding unless they have a separate confidentiality agreement. Nor does current law typically preclude a party from disclosing information obtained in the arbitration process or any resulting award. Arbitration is usually less expensive and faster than litigation.
The gentleman's time has expired.
30 more seconds.
Madam Chairman, I yield an additional minute.
Arbitration is usually less expensive and faster than litigation. It normally minimizes hostility, is less disruptive ongoing future business dealings, and is often more flexible. This legislation does not favor the American consumer. The only ones favored are the unions and the trial bar. This is not right for Americans, and I urge my colleagues to vote no on this unfair act. Thank you.
Madam Speaker, I reserve the balance of our time.